Well, good morning, everybody, and thank you for attending this year's St Ives Property Seminar, focusing on ToLATA claims. I'm Preaction, barrister here at St Ives, and I will begin shortly by setting out a case study that will form the basis of the seminar today. After that, our first speaker is Anya Newman, who will take us through the initial stages of a claim, including pre-action and taking instructions from your clients. David Nuttall will then speak about the advice to clients from pleadings all the way through to trial, including relevant case law, the evidence required, and preparation for each key stage. Michelle Caney will speak on the same issues, but from our defendant's perspective. And finally, Eloise Marriott will discuss the issues, but also take us through remedies available to both parties. Just a couple of points of note before we begin. We're hoping to have a break at about 11:30 for about 15 minutes. This will take place around the CCMC stage of our case study. The session is being recorded and the slides will be sent out to you after the seminar. Also, if you have any questions throughout, if I can ask you to please use the question and answer section. And we will go through as many of the questions as we can after I have handed down judgment today. So, I promised you a case study, and this is an amalgamation of different cases and scenarios we've all come across, full of intrigue and deception. And we hope that it will address many of the key points in ToLATA claims that you will have come across too. So today we have Ahmed and Nina. They have been together for 30 years. They're not married. And they live together in a property called Number 1 Teddington Terrace. They think it's owned jointly, but can't exactly recall how they purchased the property. Teddington is a 5-bedroom Georgian property worth in excess of £1.5 million. Unfortunately, Nina and Ahmed have now separated. Nina is a little bit miffed. She loves Teddington. I'm sorry, we've just had a query on the chat that there's no audio. And Elizabeth Ashford has said she can't hear anything. Is there anybody else having issues with the... Oh, sorry, Elizabeth, it might be at your end then. Oh, good. Right, so Nina's a bit miffed. She loves Teddington and she comes from a very wealthy family. She recalls that her deposit contribution was somewhat higher than Ahmed's. If he contributed anything at all, she can't really remember. She's always dealt with the upkeep of the property. She's very proud of the house, and she paid for a major refurb a few years ago. Nina and Ahmed have 2 adult sons that both live at Teddington, Neil and Sam. Since reaching adulthood, Neil and Sam have contributed to the household costs and a few other expenses. For example, Neil helped his mum with the refurbishment a few years ago. He spent his own funds on an extension. He added a 6th bedroom, some additional living space, and a football-themed man cave. Sam pays for a lot of the day-to-day expenses at Teddington, such as utilities and council tax, which are relatively high. Sam also takes the family on 2 to 3 luxury vacations a year. Ahmed is now retired, and he handed day-to-day conduct of his property business to Sam. The property business's main asset is an apartment building called Pershaw Court. Since Sam has started working with his dad some 6 years ago, he's invested any spare cash he had in the apartment building and the property business in general. The apartment building itself is owned by Ahmed outright, but it was Nina's family money that assisted in its purchase. Ahmed and Nina have been separated for 2 years, and on the advice of a friend, Nina served a notice of severance in 2019. Since Nina left Teddington, stay with me, she has been living at 2 Lime Grove. Now, again, on the advice of her friend, Nina has brought a claim against Ahmed, or wishes to bring a claim against Ahmed, for 50% beneficial interest in the property business and 50% in Teddington. At least 50%, she says she's owed. Ahmed and his sons want to defend the claim on the basis that she cannot be entitled to 50% of Teddington, and that it was Nina's decision to leave. Ahmed is also counterclaiming for 50% of Lime Grove. He says that there was a declaration of trust to that effect after the purchase. Nina is adamant she used her own money to purchase Lime Grove and has paid for everything since purchase. So that's the basic outline of our case study. Like all claims, we will be provided with more in-depth information as the matter progresses. But I'll now hand over to Anya for the initial section, taking instructions and pre-action.
I'm going to address taking initial instructions from your client. I'm often surprised at how many times a cohabitation case might get to counsel for advice when there are some really fundamental pieces of information that are missing from the file. That, of course, increases the costs and the delay for the client, as either the advice is going to be provided on the basis of some assumptions, or the file is just going to be returned, pending further investigations being done. In this section, we're going to look at what information should be ascertained from Ahmed and Nina pre-issue in order to try and to save costs and time on drafting and enable a better view to be taken at an earlier stage on the risks of the case. We're going to cover the advice that all clients should get, which it seems Ahmed and Nina are very keen to skip over in their determination to hurl rocks at each other in court. We're going to look at some general tips as well, in order to give a fuller picture of the sorts of things that would come up when a client first walks through your door. So first of all, the basics, and forgive me if these things are obvious, but the first thing you need to do obviously is explain the purpose of pre-action protocols and the need to consider settlement. This may be a new concept to clients. They may not understand that there are other options other than going all the way through to trial, but they need to appreciate that the courts will expect them to have considered some form of settlement, and certainly that will be very relevant later when we come to costs. Secondly, this comes up quite often. It may be necessary to explain to your clients that there is no such thing as a common law husband or wife. A survey in 2007 found that over 50% of cohabitees believed that there was, and that they therefore had rights as a common law husband or wife. Those that didn't believe that, those thought that the law was about to change. And of course, there is constant talk of the law changing. And that led couples to be complacent and to think that they would get protection under the law fairly soon. So there are a lot of misconceptions that clients may walk through your door with. I think it's helpful to illustrate the cost and the potential timescale of a contested hearing. If you've got a couple of anonymized cost schedules to hand, then that can help to show a client exactly what they may be in for. And of course, costs of issue can be high. So even just demonstrating that starting court proceedings is something that may need a warning. It should be explained initially that the risks of litigation are high. I've had cases that I was absolutely convinced that I was going to lose, and I won. And I'm sure we've all had cases that we were convinced we were going to win and we've lost. There can be no accounting for when a client gets up and starts giving evidence, and there really isn't any accounting for what a judge might think of your case. So that should be laid out initially. It's worth mentioning that you may need specialist counsel straight away. Advice and drafting is going to immediately increase the upfront cost. And the importance of obtaining the conveyancing file and other relevant documents should be stressed. Explain the duty of disclosure that will happen if you start court proceedings, that there's no point in holding back at this stage, that they may as well be honest and give you the documents that you require. I'm going to outline the shape of the law before handing over to David later, who's going to deal with the law in more detail. But of course, initially, it may be helpful to explain to the clients that there are sort of two forms of getting your interest in a property. There's, of course, firstly, the express declaration of trust. Now, that, as we all know, is the most straightforward way of managing property, which was purchased by cohabiting couples. Unfortunately, therefore, we rarely see it. It'll be a declaration made in writing, and that will record the beneficial interests of those entitled to them. Sometimes you may find that what you need to do is simply explain the effect of any express trust deed and investigate how best to quantify interests. Now, the express trust does not need to be declared in writing at the time of its creation. A subsequent declaration would suffice, so long as it's formalised before a dispute arises. And be wary of TR1 box 10, the land registry form. That has a box in where upon purchase, the intention of the parties can be indicated, either as joint tenants, tenants in common in equal shares, or tenants in common in unequal shares. That would count as an express declaration. David will be coming back to that later. So what about the more usual case that we deal with when you've got no express trust? Establishing an interest, how is that possible? There are obviously ways that you can advise your client that they could establish an interest, but we need to be mindful of the fact this is going to be more complicated, it's going to involve more cost and more delay. There are obviously, as we know, the three main methods of establishing the interest: the constructive trust, resulting trust, proprietary estoppel arguments. Quite often the difference between constructive trust and resulting trusts are lost on clients. I think the easiest way to explain the difference is to explain that in a resulting trust, the quantification of shares as between them and their other half is based on their contribution. Whereas in a constructive trust, the court will have a wider remit when ascertaining the extent of the parties' beneficial interests in their property. I'm going to talk briefly about proprietary estoppel as well. We need to recall that there are three basic elements. I would urge people to have it in mind when taking initial instructions. I find that proprietary estoppel is sometimes it's an argument which can be overlooked in favour of the trust arguments. And remember the three remits: was there a representation or assurance by one party to the other that they will acquire property rights? Did the party that received the representation rely on that to their detriment, or did they change their position in reliance on the representation? And would it be unconscionable for the owner to deny the party who acted to their detriment the right? So bear those things in mind as well when taking instructions. Okay, let's move on to Ahmed and Nina. Finding out about the relationship. With any cohabitation claim, the first thing you're probably going to want to do is firm up your instructions on the relationship itself. So let's look at this. I've written a checklist here. There's some fairly obvious things: the date the relationship started, the date of the cohabitation, the date of birth for any children, dates of an agreement to marry, and termination of any agreement. What does the client understand about the cohabitation arrangement and the property? Did they agree to anything? Details of any acts of reliance or detriment. What were the financial arrangements at the start of the cohabitation? Did they change? Were the finances pooled? And when did that occur? When and why did the relationship break down? And what does the client think that the other party will want? That's often quite useful to give you a heads up and maybe help early settlement possibilities if you know what the motivation is of the other party. Now, in this case, we know that Ahmed and Nina have been together for 30 years. But there's more to it than that. When asked whether they moved in together before they purchased the property, Nina says yes, they did move in together in a rented house before they bought the property. You ask for the dates of birth of Sam and Neil and check that there are no other adult children from any other relationships. And Nina discloses that both of the sons are adults. They both have jobs of their own. There are no other children to complicate things. You ask whether they were engaged to be married. If so, when did that end? Because, of course, we know that an agreement to marry means that Section 37 of the Matrimonial Property and Proceedings Act will be available. And that enables the court to take into account a contribution in money or money's worth to the improvement of real or personal property when assessing a party's beneficial interest. Nina says in response that, yes, they were engaged to be married, and they had a fabulously expensive party about 15 years ago. However, when pushed about when that ended, Nina says she told Ahmed soon after that she didn't want to marry. You ask for some evidence of that. You see that she does have a very expensive diamond ring, although she's wearing it on her right hand, and she concedes that she did continue to wear the ring on her left hand for many years, and that there will be photographic evidence of that. She cannot remember when she swapped the ring over. Nina says that she left because she fell out of love with Ahmed, and she didn't think it was fair on anyone to continue the relationship. So you know that she wasn't booted out of the property. Next, you'll want to find out about the property itself. I've written a checklist here, some obvious things that we'd want to look at, obviously the addresses, dates and costs of purchase. Do they know how they purchased it? Do they remember what they ticked in box 10 on the land registry form? Probably not, but it's worth asking. Get the names of the solicitors who acted on the purchase so that you can obtain the conveyancing file. Find out, if you can, what information and advice was given by the solicitor acting on the purchase. Check that whether there may be a potential negligence claim. Need to find out, obviously, whether there are any express trusts in place or declaration of beneficial interests. Make a full list of things like the purchase price, contributions, loans, hard and soft loans, because of course there may be family money behind it, and you'll want to write that down too. Make a list of contributions since the purchase, so the mortgage payments, the renovations, the non-financial contributions. Get the best valuation you can. It may be quite easy to do. In the case where you've got a, say, 1930 semi on a street in Solihull with a lot of other 1930 semis, you may be able to have a quick look on Rightmove, a quick look on Zoopla, and establish within £20,000 to £50,000 how much that property is going to be worth. But it may be that you've got something really unusual and you're going to have to send an expert out to get that valued for court. Of course, you can always ask an estate agent to pop round and get you a quick couple of opinions in order to get an idea of the value of the property. Get the mortgage details and the redemption figure, obviously. And also ask whether any legal steps were taken before you were instructed. Now, turning back to Ahmed and Nina, in this case, they can't remember how they acquired Teddington Terrace. It's going to be important to get the TR1 and the conveyancing file immediately. Once we do, it transpires that they did indeed purchase as joint tenants. They purchased it in 2001, and it cost them £500,000. Nina, it shows, contributed more to the purchase price. She did, in fact, pay £200,000 and Ahmed put in £50,000. They had a 25-year mortgage for the rest, and her legal team will need to get the evidence of her contributions. Can she show the bank statements showing the money leaving her account, for example? How can she explain obtaining the deposit monies in the first place? As to contributions to the mortgage, Nina states that she'd always paid 2/3 of the mortgage, and she still does, even though she has now vacated. You ask why there's still a mortgage in place, given that they originally had a 25-year mortgage. Nina says that there was some equity release, and so she's increased the mortgage, but she's not very specific about what that was used for. Nina paid for a major refurbishment, but when you dig into that, she says that she spent £15,000 on soft furnishings and redesigning the garden. You ask whether the soft furnishings are going to stay with the property, because she's insistent that she spent a lot of money on the house improving it herself. She says no, she loves her curtains. She would be taking them with her if the property was sold. The garden design does remain, but Nina isn't actually sure whether it's nicer than the previous garden that she had. So when pushed, she actually accepts that she can't say that the £15,000 she spent increased the property's value, but she did like it, and she's always joked that Teddington Terrace was her house that she let the boys stay in. You ask where the money came from for the refurbishments, and Nina said it was from a bonus at work. You might need to get evidence of that if you think that this is something which is going to be important going forwards. Ask her whether there are any discussions about the implications of her paying for it. She says she can't remember whether there were any such discussions. Can she evidence paying for that refurbishment anyway? She says she'd need to speak to her friend who's a designer and did most of the work. As we've heard, Sam and Neil do appear to be heavily involved in the financial arrangements for the family home and the apartments. Ask for some details of this. Find out why they're so involved, whether there are any express agreements in place, any promises that have been made to them that they have relied on. In terms of legal steps, we find that Nina has served a notice of severance. You find that that was in 2019. When you obtain that document from the conveyancing file, you do conclude that it is indeed valid. Moving on then to consider Pershore Court, which is the business interest, the apartment block. We've been told that the property is legally held by Ahmed, but what does that mean? In these sorts of cases, you want to find out whether there's a limited company involved. If there is, who are the shareholders? When was it formed? What's the nature of its business? Is it dormant? Is it active? Can you get those accounts? How was the property owned by the company purchased? And has that property ever been the family home? But specifically looking at Pershore Court in this case, when you ask Nina about it, you find out that it was indeed purchased in around 2001 for £1 million. Nina and Ahmed both contributed 125,000 to the deposit. Ahmed holds the title alone. There is no limited company involved in this case. Nina's initial instructions are that the property might be worth £5 million. However, when you start investigating that, you get a valuation back which suggests it's really more around 2 million. Nina's family contributed money to her part of the deposit. Ask her why. Can she evidence that? Ask for bank transfers if you can. You'd want to ask what the family agreement was. And she says that it was simply that she'd pay her parents the money back with interest at some point later. In those sorts of cases where you've got an agreement between family, it's quite important, I find, to take a written account of the oral discussions concerning the property arrangements. This isn't just, oh, well, I agreed with my dad that he would lend me 20,000 and then I would pay him back 5 years later. That probably isn't going to be enough to persuade a judge. Ask more detailed questions. Things like, where did the discussion take place? What time of day was it? Not just the date. Was the meeting planned in order to discuss the issue of property, or did it just come up? Was it a special occasion? Was it Christmas? Was it Easter? Who else was there? Was it in a public place like a cafe or a restaurant? And if so, would there be a credit card statement showing the bill that was paid that day? Those sorts of things are really important. Even something as silly as what food was being eaten might be enough detail to swing a judge to accept that kind of meeting took place. I recently had a case where there was this sort of alleged meeting, and all of the witnesses confirmed that they had eaten shepherd's pie at the time of the meeting, and that was enough to convince the judge that indeed the witnesses were all telling the truth. So small, silly details can really make the difference in terms of evidencing those meetings and discussions. Nina says that the agreement happened over Easter dinner one day. They were hosting at Teddington Terrace. It was her parents who were there, and they were talking about wanting to make an investment for the future. She says her brother was also there. It was lunchtime. Ahmed had cooked, but she can't remember what they ate on the day. Nina says that she'd had no involvement with the running of the apartment building, nor has she put any money into it. She considers it Ahmed's thing, but she doesn't want 50% of its value, but she does want 50% of its value. So looking generally at the evidence that you need to get, we all know you want the file of papers from the solicitors acting on purchase, title deeds and any documents with express declarations of trust, evidence of contributions made, documentary evidence, evidence oral or written of agreements and understandings. As I've said, take a very detailed note if you can. Documents like mortgage applications, text messages, cards, love letters maybe, cohabitation agreements, emails. And we'll come on in a moment to look at what would you do if the disclosure was refused. So in this case, we've got three purchases to consider. We've got Teddington Terrace, we've got Pershore Court, and we've got Lime Grove. So the family home, the investment property, and the property that Nina then moves to. Contributions come from various sources. You ask for evidence. Nina drops off a box with 25 years worth of bank account statements and pay slips in. You've got to warn her then obviously about the costs of going through the documents. She'll take them away to highlight the relevant points, but you're still going to need probably to go through them at a time to check for nasty surprises in there. With regard to the apartment building, in Nina's case, she doesn't legally own it. And in Ahmed's case with Lime Grove, he doesn't legally own that. You'd want to see the conveyancing file, but you aren't necessarily, you're not entitled to it. You wouldn't have a right to it because your client wasn't the legal owner. So of course, that would be the time to request it in pre-action correspondence. Very important to do so. If it is refused, and do ask first, then you might want to consider whether it's going to be proportionate to make an application for pre-action disclosure. Those applications are made under Part 23. We all know they need to be supported by evidence. We need to warn clients that normally it's the applicant who pays the costs of those applications, so there is certainly a downside. In terms of tactics with those applications, put the class of documents that you're seeking as simply as possible. The more complex the argument about why you need to see something, the more likely it's going to fail, and the judge will say, I'm sorry, this is not really truly a pre-action disclosure point. So try and simplify it. If you're trying to get a conveyancing file from a purchase your client was not involved with, you may often come across the other side solicitors trying to block you, saying, well, it's a privileged file, you can't have it. Take care to distinguish between documents in that file which are truly privileged, so documents which actually have advice in them, and documents which aren't privileged at all and are just sitting in the solicitor's file. That can normally be a way to get several key documents that you will want. Finally then, Lime Grove. This is the property that Nina buys on separation. The property that we've heard she owns legally, but Ahmed says he's got a beneficial interest and has an express declaration for. With this case, you're going to need to get that conveyancing file immediately for Nina. You want to find out the information from Nina about how it was purchased, referring back to all the things that I've already discussed about showing her contributions. You need to seek evidence to corroborate that. And of course, obviously, we need to take instructions on whether Nina accepts that that express declaration of trust is actually correct. Does Ahmed, for some reason, own a 50% interest in a property that she bought post-separation? Now, Nina tells you that she's got absolutely no clue about any declaration of trust. She believes she bought the property outright from her savings for £175,000 in or around 2019. You ask her for evidence of the transfer. The conveyancing file is received, and we see from that there is no mention of Ahmed's involvement in the purchase at all. Nina, when pushed, does recall being asked to sign something official looking by Sam around the time of purchasing Lime Grove, but she can't remember what it was. She thought that it related to the apartments at the time. She didn't really pay it much attention. You get the copy of the express trust. Nina doesn't recognise her signature on it. It's rather faint. She's not able to say that it's definitely not her signature. I think we need to start thinking about fraud here. Do we need a handwriting expert? Well, firstly, we need to see the original so Nina can see whether she does accept that's her signature. And then, of course, if not, that's when you would start to look at whether you need a handwriting expert in the case. When asked in more detail about Lime Grove and how she found the property, she discloses that the property was initially considered by the couple as a joint purchase to use as a holiday home in late 2018. She discloses a mortgage application from her and Ahmed for the property they filled in together, but she says the application never went through and they split up before the purchase. After the end of the relationship, she decided to buy Lime Grove anyway because she'd fallen in love with it. Nina says she thinks she might have some WhatsApp messages from 2019 when she explained to Ahmed that she was going to purchase the property that they had been looking at to buy as a holiday home together. So you get those. But when you get them, you see she's mainly apologising and saying she hopes that he isn't disappointed, that she will be the one to enjoy it. There's nothing overt in it about the purchasing arrangements. After you've taken your full instructions, you send out a letter of claim. And now I'm going to hand back over to Priya.
Thank you, Anya. I appreciate that's a lot of information that Anya has elicited from Nina. So I'm just going to recap the instructions from both sides. From Nina as the client, and post letter of claim, we did receive a letter of response from Ahmed. So in the background to the relationship, there are two adult sons, Sam and Neil. They're both self-sufficient and they both live at Teddington. Nina and Ahmed rented a property together prior to the Teddington purchase. The relationship ending was Nina's idea. It was her decision to move out of Teddington. They were engaged but never married. Again, that was Nina's decision. The background to the Teddington purchase. The TR1 shows us that Nina and Ahmed purchased Teddington for £500,000 in 2001 as joint tenants. Nina contributed £200,000 to the deposit, and Ahmed contributed £50,000. The remainder was subject to a 25-year mortgage. Nina has always paid, she says, 2/3 of the mortgage and has continued to do so even after leaving the property. Although relatively low, the property remains subject to a mortgage due to an equity release some 10 years ago. A few years ago, Nina paid for some refurbishment. It turns out this was major garden works and some expensive soft furnishings. She would like to keep the furnishings, but appreciates the garden must stay where it is. She cannot confirm whether her refurbishment has increased the value of the property, although she is adamant that she always joked that it's her house and she let the boys stay there. A valid notice of severance was served in 2019. And Nina wants an equitable account, and her claim includes occupation rent. She claims more than a 50% interest and is considering an order for sale. The background to Pershaw Court, purchased in 2001 for £1 million. Nina and Ahmed contributed £125,000 each. Nina maintains that both her and Ahmed's deposit contribution came from her family, but cannot remember why. Ahmed is the sole legal owner. It's not owned by the company. Pershore Court is now valued at £2 million. Nina says that the intention was always to pay the family back upon sale of the building. In relation to the deposit, Nina vividly remembers asking her parents for the deposit over lunch at Easter. She said she told them it would be an investment for Sam and Neil in the future. She admits she's never had anything to do with the upkeep or running of the property business, but she does believe she's entitled to 50% of its value, since without her, there would have been no investment. Lime Grove. Nina cannot recall a declaration of trust. Her signature is faint and she doesn't recognise it. As far as she's concerned, she purchased that property in 2019 for £175,000 using her own savings. She remembers signing something that Sam gave her around that time, but she doesn't recall Ahmed having anything to do with the purchase. The conveyancing file when we receive it is clear, and Ahmed's not mentioned. The couple did consider it as a holiday home, but Nina states that Ahmed knew she was buying it for herself. Unfortunately, there's no contemporaneous evidence either way. So after we've sent out the letter of claim on behalf of Nina, we receive Ahmed's letter of response. What I'm going to go through now are just the contrary instructions. There is a lot of it that he does agree with, but these are the things that he doesn't. He disputes that Nina has paid 2/3 of the mortgage. She always had access to his money, and she actually paid out his own money. She had access to his bank accounts throughout their relationship. Ahmed says that he has been paying the mortgage since she left, and she's lying about the fact that she's paid it since 2019. She may have joked about it being her house, but that was just a joke. He just liked a quiet life. He didn't want to argue with her. Ahmed wants to robustly defend Nina's claim to more than 50% equity of Teddington. He says it's 50-50 at best. In relation to Pershore Court, the investment property, he denies that Nina's family contributed his share of the deposit. He goes further than that, actually, to say that Nina's share of the deposit was a gift to him, for him to start an investment business that would benefit the whole family. All mortgage payments in relation to Pershore Court have been paid from rental income. He wants to defend Nina's claim for any interest in the property business and states she's not entitled to anything. Lime Grove, where Nina moved to when she separated. Ahmed admits that the property is in Nina's sole name, but he asserts a beneficial interest. He evidences a declaration of trust that Nina holds the property on trust for him and Nina in equal shares. He admits that he made no contribution to the purchase or the upkeep of Lime Grove. And he remembers that the declaration of trust was just drawn up between them and there were no solicitors involved. So now we know what both parties' instructions are. Counsel has been further instructed to advise on the claim and settle the pleadings. So I'll pass you over to David.
Priya, thank you very much indeed. Contrary to what might be shown on your screen, I'm not Anya Newman. I'm David Nuttall, and I'm going to be dealing with the stages of this case once it comes to counsel and what it is we need to be looking at and dealing with to get this matter towards some sort of resolution. So we can assume that this case is going to be heading towards a ToLATA claim and that an order under section 14 of ToLATA is going to be sought by Nina. she's going to be asking for some sort of declaration as to her interests in these various properties. Now, Eloise later on is going to be talking about the specific remedies. So I'm not going to be touching on things like equitable accounting or occupation rent or the principles behind orders for sale. I'm going to simply be looking at the establishment of interests in these properties and the basis on which the court might grant a declaration to that effect. Now, Anya's already touched on some of the legal principles with at least a view to taking instructions. I'm going to be going into it in a little more detail. I'm sure a lot of you will have already recognized that Nina's going to have some degree of difficulty in this case because Teddington is subject to an express declaration that she and Ahmed are joint tenants. And so we are going to have to deal with that. She's going to have to probably be given some quite robust advice. But in any event, that's not the end of the road. And there are going to be mechanisms that we can look at for getting around that. But in terms of the basics, and this no matter what sort of trusts case I'm dealing with, these are the sorts of steps that I'm always going to be going through, especially in domestic context cases. The starting point is, of course, that equity follows the law. So if we know what the legal interests in the property are, then we have as that starting point that the beneficial interests are going to be the same. And the importance of that, although it might seem obvious, the importance of that is that it sets out where the burdens of proof are going to lie. So if we have a sole ownership case, as in one person owns the legal interest in a property, we know that whoever's going to be after the beneficial interest is going to have that burden of proof. And equally, if we have a joint ownership case with tenants in common as the beneficial owners, we know that if someone's going to be arguing for something different to a 50-50 share, then again, the burden's going to be on them. But the starting point of equity following the law was reiterated, made perfectly clear in Stack and Dowden. I'm not going to go into Stack and Dowden, into its facts. They're well known, the principles are well known, but Stack and Dowden very much consolidated all of the law that had gone on up to that point and really set the agenda for the next 14 years of evolving case law on domestic cases like this. So what we can take from that and what we can take about the principles are that, yes, the beneficial interests can be different to what the legal interests are, but as I've said, the burden of showing that's going to be on the person who wants to establish a beneficial interest that's different to the legal interests. And most importantly, that establishment. So forget about shares for the minute, forget about quantification, simply the establishment of the point that beneficial interests are different to legal interests has to be on the basis of a finding of fact by the court. And that finding of fact is that there was some kind of agreement between the parties. And that ideally will be some sort of express agreement, but it just as easily could be an inferred agreement and usually is. But there has to be that finding. And sometimes people get a bit unstuck with these kinds of cases because there is this assumption that just because parties have lived together, because there have been some sharing of obligations and things like that, as would happen in any relationship, that is enough to develop some kind of beneficial interest over time. And that's simply not sufficient. There needs to be at all times an eye kept on exactly how we're going to establish the beneficial interest, the point in time where it came into being, whether that's at the point where the property was purchased or later on. Now, that's going to be more relevant for sole owner cases, sole legal owner cases, but equally relevant when we're saying there's some kind of change in beneficial interests over time. That has to be on the basis of an agreement. And that's perfectly clear from Stack and Dowden, and later cases like Jones and Kernot didn't change that. There's no basis for imputing an agreement. There still has to be something that you can point to. I've said that the agreement can be based on inference, and it's the old position based on the old rules about resulting trusts, that contributions to purchase price are going to readily raise that inference that there was some sort of agreement between the parties, that both of them would have some sort of interest in the property. So if you have one sole legal owner, the TR1 says nothing about any trusts or anything like that, but that sole owner's partner contributed towards the purchase price, the court is going to infer that there was some sort of agreement between the pair of them, that the beneficial interests weren't going to follow the legal interests. And that's taken from the older case of Lloyds Bank and Russett, which in my view has entirely survived Stack and Dowden and remains the case. It's only a starting point. That presumption can be rebutted, but it is a ready inference to make. All of that being said, express declarations of trust are binding and exhaustive. And again, Stack and Dowden did nothing to change that. We see that from the older case of Goodman and Gallant, which I'll be talking about in a bit more detail later, and also the rather more recent case of Pankania and Chandegra, which again I'll be touching on, and I know Michelle's going to be talking about. But the upshot of that is that when you do have an express declaration of trust at the point of purchase or later, it doesn't matter whether there were contributions towards the purchase price. It doesn't matter what the parties then subsequently did as between themselves. That express declaration binds them in terms of their starting beneficial interests. And that, as we'll see, is the situation, at least with Teddington in this case. Assuming that's not happened, if one party has established a beneficial interest, then that can change over time. That would need to be established by way, again, of an inferred agreement. It's not as easy, again, as just saying, well, you know, the party's situation changed over time, therefore their interests should change as well. The court needs to go that step further and actually point to something as to why those shares have changed. And again, that's taken from Kernot and Jones. So in a case like this, there's a few steps that I would be going through to work out how we're going to be putting the case. Again, same in pretty much all cases. You can break them down into this. We look at, for each property, what's the legal ownership? Well, with Teddington, we have joint legal ownership. With Pershaw Court, we have sole legal ownership with Ahmed. We look at the point of purchase or later, whether there's an express declaration of trust, which just ends the question about beneficial interests. With Teddington, it looks like there was one. With Pershaw Court, there wasn't. If we don't have that, we then move on to the next step. We look at whether there was anything at the point of purchase which might give us either a presumption or a strong inference that there was some kind of agreement to establish a beneficial interest. So I'm talking, of course, there about purchase price contributions, or as time goes on, mortgage contributions, at least to capital. And if we don't have that, or even if we do, we then look as well at wider circumstances to see if there's anything on which the court can infer that agreement to change the interests, and then whether that might have changed over time. So in this case, I've broken those steps down, in relation to both Teddington and Pershaw Court. As I was going through just then, legal ownership is perfectly clear on both, won't be difficult to find out, at least in registered land. Initial beneficial interests, Teddington, we know that. We know what they were. They ticked the box in box 10 of the TR1, they're beneficial joint tenants. Pershaw Court, there's nothing immediately to tell us that Nina has any particular beneficial interest, so she's going to need to establish something. if she can establish that she has contributed to the purchase price and that that wasn't a gift, then of course there's going to either be the presumption of a resulting trust, I'll come back to that in a second, or at least a strong inference as to an agreement that there's going to be some sort of common intention constructive trust. And then as time went on, we look at that with Teddington. The joint tenancy was severed when Nina moved out. Possible question mark about whether it was severed earlier, probably not, but that's something you'd be looking at. But that notwithstanding, we know that her share doesn't change because there is this exhaustive declaration. So we're going to have to look at some of the other possible mechanisms for departing from that declaration. And I'm going to be touching on proprietary estoppel, the effect of her engagement to Ahmed, and possibly whether there was an ambulatory constructive trust that might have changed the shares, but that's a bit of a bold argument. With Pershaw Court, nothing really on the facts of this have changed over time. Nina's contribution was at the start, and that was it by the looks of things. And then based on all of that, what is it that everyone's seeking? So I've mentioned that we have this problem with Teddington, which is that the joint tenancy has been declared from the outset. And the case on this is Goodman and Gallant. Now, in that case, where again, there was an express declaration from the outset that they were joint tenants, the appellant was trying to argue that, well, yes, they may well be joint tenants, and that may well be completely exhaustive by way of declaration as to their interests. But when that joint tenancy is severed, then all bets are off, and the court has the ability, and the parties have the ability to argue that at that point of severance and thereafter, the shares can be, the shares will depend on their relationship and on any informal agreements they might have had. And it's for the court to determine at the point of severance what their respective shares are, or later. And there had been some authority that suggested that was the case. It all came from Lord Denning's judgments in various cases where he had very much taken the view that the court should keep a role in determining interests, notwithstanding declarations as to joint tenancies. And what the conclusion of the case was that no, that's simply not right. And when you make an express declaration as to a joint tenancy, that is the end of it. You are joint tenants, but not only that, when that joint tenancy severs, that express declaration is as good as an express declaration that both parties held 50-50 in 50-50 shares. So the declaration carries over. And that's very important because, again, there's sometimes a little bit of a misconception that once a joint tenancy is severed, you can argue about shares changing afterwards, either on the basis of simply the party's intention when the property was purchased, or on the basis of an ambulatory constructive trust. So the party's conduct as time went on meant that they probably intended to hold in different shares. And Goodman and Gallant is the authority to say no. You are joint. If you were joint tenants and you expressly declared that you were joint tenants, then that answers the question forevermore, unless you can rely on one of these other mechanisms I'm going to be looking at. So in this case, that is the problem, and it's one that's going to be somewhat difficult to get over, but there are some solutions that we can look at. So the first is the engagement point. Nina and Ahmed were engaged to be married. Bit of a factual question mark over exactly when that was and when it ceased to be the case. Nina's going to have to argue that engagement wasn't broken off until they separated, but it's open to her to argue that on these facts. It's important because there's essentially a limitation period of 3 years in this sort for this sort of thing. So any claim for relief under the Matrimonial Proceedings and Properties Act 1970 has to come within 3 years of the breaking off of the engagement. So she would need to show that engagement broke off when they separated in 2019 or shortly before that. Now, Matrimonial Property and Proceedings Act it's not as well known about as you might think for quite an important provision. And what it does, I will just read out the wording of the section. It gives the court the power where one of an engaged couple contributes in money or money's worth to the improvement of real or personal property that either or both of the couple have a beneficial interest in. And if that occurs, then subject to any agreement to the contrary, the court has the power to declare that by virtue of that contribution, the party who paid the money to improve the property will have acquired either a beneficial interest or an enlarged beneficial interest in the property. It's quite a convoluted section, but the effect of it is that if you've got an engaged couple and one of them does spend money towards improving a property, the rules surrounding beneficial interests and trusts sort of go out the window, and you find yourself, or you can bring yourself within more matrimonial finance type jurisdiction, where the court has essentially not unlimited, but a very wide discretion to muck around with the parties' shares based on all of the circumstances, of course, with reference to that any improvement that was made. So it's a powerful section. It's not used very often. It also, if anyone fancies it, can be the subject of an application to the family court or to the family division, even if the parties aren't married. So it could be used here with Teddington in relation to Nina's refurbishment to, at the very least, say that notwithstanding the 50-50 shares that have been declared by way of the box 10, that she's acquired something additional to that. Probably difficult to argue that what she's acquired is much more than any increase in value, the value of any increase in value that her improvements led to, but not impossible. And what it's doing is opening the door to have the argument. And that's what really the point of this is. The point of chucking this in is so that Ahmed's advisors can't just sit back and say, well, declaration of joint tenancy, that's the end of it. It's about bringing in possible doubt so that if we can bring this to the table, we've got something we can point to. There was a case called, fabulously named Dibble and Pfluger in 2010, where the Court of Appeal were actually critical of parties for not having raised this point within a wider ToLATA claim, where it plainly would have been relevant. The parties didn't raise it, and the judge at first instance therefore didn't pass any comment on it. But the Court of Appeal said it absolutely should have been part of the parties' cases, and it might have had a real impact on the outcome. That's a useful case because there is a bit of a question mark about jurisdiction with applications in relation to Matrimonial Practice and Procedure and Property Act about whether the county court does have jurisdiction. To my eyes, it doesn't immediately look like it does, but in that case, that was within the county court at first instance. Court of Appeal said the county court should have dealt with it, so that really is the end of that. So that's the first thing we're going to be throwing into any claim that we're issuing here. The second, probably stronger point, or at least conceptually stronger point, if not necessarily factually stronger on this case study, would be proprietary estoppel. That's where we're going to really be going in this case. It is a solution to the conclusiveness of the declaration. That is pretty clear from two cases. The first one I've set out there is Clark and Miadis. Not the most relevant to a ToLATA type case, a domestic context ToLATA case on its own facts, but it makes the point that just because you've got an express declaration of trust, that doesn't mean that proprietary estoppel cannot step in to change the party's shares, which would have the effect of severing a joint tenancy at the time, or at least at the time the court makes any kind of order. Unfortunately not binding, because it was an appeal on a summary judgment strikeout application, but the court's comments in finding that there was a real prospect of success were pretty clear that proprietary estoppel can step in here. And it was mentioned, although not in a particularly binding way in this case of Pankania and Chandegra, it was thrown in by the Court of Appeal as being a mechanism for getting round express declarations, and it seemed to be simply accepted that that was the case. So it's certainly very arguable that you can rely on this. What do you need to make out proprietary estoppel? Anya's already told us, but just to reiterate, you're going to need a sufficiently clear representation. Court's perfectly clear now that that doesn't mean contractual language. It needs to be seen in its context, and in a family case, or a domestic case, I should say, that context will be extremely fact specific. But it does mean that you don't need something quite so clear as you might be expecting in, say, a commercial type case. The general feel of the communications between the parties is going to be very important. The context in which communications took place is going to be very important. And the court can take a wider view about the overall relationship to determine whether or not this representation was made. That all comes from Thorner and Major, but it's the tenor of all of the cases that have more recently been in court. We need to show a detrimental reliance. That doesn't need to be financial. It doesn't need to be referable to any financial detriment. It is, again, in a domestic context at least, something where all the circumstances are going to be considered, so that the court can take a view in the round as to whether there has been some detriment faced by the person who's relying on that representation, and that's clear from a case of Gillett and Holt, and again subsequent ones. Something that's sometimes overlooked with proprietary estoppel is what the effect is, and sometimes you can have entire trials about what the actual effect of a proprietary estoppel is, as opposed to whether one's been established. Because all the proprietary estoppel does once it's been established is it raises an equity in favor of the representee. And it's the court's job then to work out how can that equity be satisfied justly. And there's all sorts of different ways that that equity can be satisfied. It has to be with reference to the detriment. But beyond that, it can either be simply compensated in money, or it can be compensated by way of fulfilling the representation with an order that the property changes hands, something like that. So in the facts of this case, the best that Nina's realistically going to be able to do is show that there was some sort of representation, although frankly, she's going to struggle, but some sort of representation that when she spent the £15,000 on refurbishing this property, that she understood that either she was going to recover that £15,000 in some way, or that she was going to acquire some sort of interest based on all of her contributions up to that point. But that's not really what the facts say. That might be what the lawyers want to show, but that's not necessarily what the instructions are. So probably she's not going to do much better than showing a £15,000 reliance here. And so the court would then have the difficult decision, if even if you could establish that there had been a representation and reliance on it, the court would have to determine, well, how are we going to satisfy that equity? And probably here, it's pretty unlikely that the court is going to say, well, she should, by virtue of that £15,000 as against £1 million odd property, gain some sort of substantial interest in it. Probably the court will simply be saying something along the lines of she can be compensated by some kind of monetary payment. And that is often what happens, because it's often the case that the reliance is so proportionately smaller than the value of the interest that the claimant wants, that there's no real other outcome. And that's probably what will happen here. Moving on to Pershaw Court, I'm going to let Michelle do most of the heavy lifting on this one, but the starting point is that Stack and Dowden doesn't apply because it's a investment property. This is not the family home. In the case of Lascar and Lascar, which is 2008, shortly after Stack and Dowden, Court of Appeal case, was clear enough on this, that all of the principles that were set out in Stack and Dowden were to apply to a domestic family home. And that even where you have a domestic relationship, if the property that you're talking about is an investment property, Stack and Dowden is probably not going to apply, and we're just going to be falling back on older, more established principles about trusts. And so here, we can look at resulting trusts. Under Stack and Dowden, generally anything that you might have once upon a time called a resulting trust is now just going to be a common intention constructive trust, where the financial contribution simply shows the an inferred common intention. But when you're outside of Stack and Dowden, you can rely on the old principles of resulting trusts, and that's what essentially happened in Lascar and Lascar. So by resulting trust, what I'm talking about here is that the money which, in this case, Nina paid, if it can be established it wasn't a gift, the money that Nina paid for the purchase of Pershaw Court was initially being held on trust for her by Ahmed, and then when he purchased Pershaw Court, the proportion that money paid for of Pershaw Court, again, was being held on trust by Ahmed for Nina. And that all works by way of presumptions in resulting trusts, and that's why it's quite powerful. You don't need to prove, even if there was going to be a ready inference, you don't need to prove that there was any kind of shared intention. The payment of the money and the use then of the money to purchase the property is enough to create the resulting trust. The burden then shifts onto the alleged trustee, onto Ahmed, to show that actually, as a matter of fact, that money was supposed to be a gift. So a useful tool here, and certainly the first thing that I'd be pleading, I'd throw in a common intention constructive trust as well, and be saying as an alternative, or further and alternative, that if for whatever reason resulting trust doesn't work, we've got a common intention constructive trust on the basis that the contribution of the money shows that common intention from the outset. That also possibly opens the door for showing that Nina's share in Pershaw Court is greater than the amount she contributed. That's going to be a tall order in any case, especially in this one, because on the facts, there's just nothing to suggest that there should be a higher proportion. But there could be. Again, she would have to point to some sort of agreement, inferential agreement at least, at the outset, that she'd hold more than her proportion, or that agreement kicked in later down the line, so that you can show an ambulatory constructive trust. various ways you could show that. Express discussions are obviously going to be pretty helpful, either at the time of the purchase or later. If her contribution to Pershaw Court was part of a wide web of transactions that were very much domestic in nature, maybe you could show that there's some basis for her having more than purely the amount that she's paid in. Going to be difficult, but you could. If she spent a lot of time working with the investment property, managing the investment property, finding tenants, things like that, and that was a sacrifice in some way for her that impacted on the domestic relationship in some way, again, maybe you could start to show that she'd acquired something more than the proportion of her contribution using the stack endowment principles. Tall order, not on the facts of this case, but it's not impossible. So issuing the claim, when we get to this stage, after we've analysed all of these different factors, we're going to have a few decisions to make. First one is Part 7 versus Part 8. The old presumption that ToLATA claims should be Part 8 does not apply anymore. There's no automatic basis for ToLATA claims being Part 8. So we just have to consider the usual principles about Part 7 versus Part 8. I've set out a couple of cases there that are worth bearing in mind in any sort of claim where this is a question. These aren't ToLATA cases. But the first one, ING Bank and Rosroka, the Court of Appeal was very displeased that parties proceeded on a Part 8 basis when it was pretty clear there was a factual dispute, and the court said that the parties should have, by consent, transferred the whole thing over to the Part 7 procedure, and not only that, but actually served pleadings, and so pretty much started again. I've had some cases, some ToLATA cases, as well as others, that have started on the Part 8 procedure because it looked like that was appropriate, but then in fact it became clear as time went on that there were going to be factual disputes, or in some cases there always were factual disputes, and Part 8 was just used as an expedient. Usually you can sort it out without too many issues, hopefully without any cost consequences. By the time you get to the first hearing, if it's become clear by then, you can just hopefully get an order saying Part 7 now applies to this claim, and just obtain track allocation and usual directions for that track without the need for formal pleadings or anything like that. I think in a bigger case where there are a lot of issues, the court probably would want particulars of claim and a defence, but might be able to streamline some of the other directions on the basis that hopefully all of the parties' evidence, or a big chunk of it, is in at that stage. Cathay Pacific and Lufthansa, a more recent case, just gave some useful guidance about if there is a question mark between Part 7 and Part 8 about pre-issue steps that the claimant ought to go through before issuing Part 8, notifying defendant of intention, explaining why Part 8 is more appropriate than Part 7. Those would seem to be pretty good practice points and easy enough to do. The slightly more onerous points are going to be drafting the Part 8 issue for the defendant to comment on, that's going to be put before the court, and then, if possible, agreeing some facts. That will make life an awful lot easier. It may mean that a case that the court thinks, oh, this is actually Part 7, can stay Part 8 if the parties work together and keep it that way. And there's all sorts of reasons why parties might want to claim to be Part 8. Keeps costs potentially down, means that you're not going to have live evidence at trial if for some reason the parties don't want that, and means you'll get your first directions hearing straight away rather than at CCMC. In this case, I wouldn't bother with any of this. You'd be issuing Part 7, you'd be drafting particulars of claim, even if there isn't going to be huge factual issues. Plainly, in terms of the remedies, the live evidence is going to be important. So I'm going to hand over to Michelle very shortly. I'm just going to, before that, go through what I would be putting in the particulars of claim in relation to both of these. These are really just samples I'm not going to read it all out. You'll be getting copies of all of these slides later on. But the point of this is to show the sort of structure that you would need. So in relation to Teddington, I've set out how you would go about pleading the proprietary estoppel claim, just making sure you're really banging on about the existence of the representation, the reliance that's placed on it, what sort of detriment was suffered, and then a catch-all sort of phrase at the bottom to just make it perfectly clear that an estoppel has kicked in, and what it is that the client wants from the estoppel is very important. That will hopefully save any particular Part 18 requests about how exactly you're supposed to be seeking this proprietary estoppel claim. But what it will also do, which is useful for everyone, is highlight where the gaps in your case are from the outset. Because if I had these instructions and was told, yeah, crack on with the proprietary estoppel claim, and I sat down and started drafting it, and this was the best I could do, I'd be immediately going back and saying, we're not going to get very far in this unless I get some quite considerable additional instructions to fill in where these gaps are. And if we can't get them, and we can't fill in these gaps in terms of what the representation was particularly, then we're going to struggle. Similarly, Pershaw Court, here a lot more straightforward. I've just set out how I'd go about pleading the resulting trust and common intention. So that takes us in all of this to the close of the particulars of claim. I'm going to go over to Michelle now shortly to talk about what she would be considering and looking at and doing in response to the claim about a defence and any counterclaim. And then we'll be going through together the steps to take us up to the trial of this sort of ToLATA claim.
Good morning, and thank you to David, Anya and Priya so far for their introduction to this interesting case, which I've just been instructed to advise and draft the defence and counterclaim for Ahmed. And as with many ToLATA claims, it's not straightforward. It may appear on the face of it to seem quite straightforward, but it becomes quite clear when one starts delving into the detail with 3 properties at issue and various issues concerning potential allegations of fraud and forgery, that this is not a straightforward claim. Before delving into the detail of defending the claim, I'd just like to remind ourselves about Section 14 of the Trust of Land and Appointment of Trustees Act 1996, which I know that Eloise will be dealing with in detail in the Remedies section. But it's helpful just to remind ourselves what the section says and the extent of the court's powers and the factors that the court is looking at in these types of claims. As we know, Section 14 allows any person who's either a trustee or has an interest in a property to make an application to the court. So that may be the legal owner if they're a trustee of the land for somebody else, or it might be somebody who has a beneficial interest either under an express trust or they claim some other form of beneficial interest, which Anya and David have been telling us about so far today. So once they get through that gateway, they have the opportunity to make an application to the court for an order under Section 1(2)(a) for an order relating to the exercise of the trustees of any of their functions, or alternatively, declaring the nature of the extent of any person's interest in the property subject to the trust. Now, subparagraph A, one always stops there because it doesn't seem to incorporate the types of extensive relief that we know is available under Section 14. But it does include, for example, as Eloise will tell us, the power of the court to make an order for sale, and we have lots of other potential remedies that the court can grant us. But the point at which people sometimes stop is that very last sentence on the slide is "as the court thinks fit." And that in itself may seem like quite a wide power and a wide discretion for the court to have. But what we must remind ourselves is that that is not an invitation for the court to rewrite history. It doesn't enable the court to simply order what is fair in all the circumstances. And we can contrast that with the matrimonial type situation where parties are married and the court has a wide discretion to make an order which is fair when it divides up the assets of the family. And the normal starting point is equality, irrespective of who owns the property legally. And the court will overlook those technical issues, which we civil lawyers know are much more at the forefront of our considerations. And of course, as David's explained, if the beneficial interest is set to depart from the legal interest, that must be proved on established principles. And flowing on from that, if there is an allegation of fraud, as I find quite regularly does arise in some form in these types of cases, it must be strictly proved. And that's something to have in mind very much when one comes across a potential allegation of fraud. And disputes concerning the ownership of the property can give rise to all sorts of arguments that may either hint at fraud or some form of illegal conduct. I'm sure we've all had the cases where a client comes to us and explains that they have a partner, they never married, but they had a number of properties that they owned, but all the properties were in the other partner's name. But of course, they always understood and believed and agreed that they were both joint owners of them, and that's the way they've always treated their affairs. And the question arises, well, why was it always put into your female partner's name? And the answer comes back, to not pay tax, for example. And then we get into all sorts of tricky issues about where that leads us. But in the more common example, we may have, as we may see in this case, a party comes along and produces a document which purports to be an express declaration of trust. And they say this is what they rely upon. That seems quite straightforward. You plead your claim or your counterclaim based on that. And then the response is, this is not my signature. I did not sign this document. And then we start going down another whole host of issues and potential expert evidence. Another example is the sham document. Quite often, again, in these cases, we have tenancy agreements, which down the line somebody might say was not actually a real tenancy agreement. It was produced by the parties with a view to providing it to a mortgage company for the purpose of obtaining a buy-to-let mortgage. So these issues crop up and can become quite tricky to grapple with. So what are our considerations for defending the claim that Nina has brought against Ahmed and any potential counterclaim that he might have? Well, as David's already very helpfully taken us through the points from the claim, many of the points are the mirror image from the point of the defence. So first, we've got to establish what the legal ownership of each of these three properties is. Hopefully Ahmed will be able to tell us, but if not, we'll be able to go pretty quickly and get a printout from the land registry to work out the answer to that question. What were the beneficial interests at the time the properties were acquired? Now, this question, as we've already seen, is a much more tricky one, and it's not going to be answered by the first question. But we also need to consider, both from the perspective of the claim and also the defence, whether or not the beneficial interest, whatever they might have been at the start when the properties were acquired, whether they've changed in any way over time, and if so, how that's happened. Importantly for us, for Teddington, what's the impact of the box 10 being completed on the TR1 declaring that Nina and Ahmed were purchasing the property as joint tenants? David's raised an interesting issue about the parties' engagement. What impact is that going to have on the claim and the defence? That is quite a niche issue that David has raised, and that's one of the things that David's very good at when he's instructed on a case. He looks right into the detail and beyond the obvious and finds things that other people might not have thought of. So I'll have to think about dealing with that in response. We need to think about what happens when Nina serves her notice of severance after the relationship has ended. Again, this is a situation which is quite common, but is quite commonly misunderstood as well as to what the effect of that is. And people often think that it's in their interest to serve a notice of severance, but it might not actually be in their interest. It may have been better to leave things as they were. And then finally, the declaration of trust in respect of Lime Grove, Nina's new property. Is that valid? we need to think about that. That's going to have obviously a crucial impact on whether or not we're able to bring any counterclaim against Nina in these proceedings. So just to do, again, the mirror exercise of what David has taken us through, considering the defence. Teddington, straightforward at the outset, legal ownership, joint legal owners, initial beneficial interest, beneficial joint tenants. So we know they both own the property entirely. And if Nina had passed away a week after the property was purchased, it would have entirely belonged to Ahmed without further question. As time went on, it's Ahmed's case that they remained joint tenants. Nothing ever changed until the severance. And at that point, it's his case that their 50-50 interest crystallised upon severance. What's his case now? He wants 50-50. He thinks that the property should be split between them. He doesn't think the fact that she made an additional contribution over and above his at the outset should matter. And he wants me to robustly defend any claim to any interest over and above 50-50. What's his position in relation to Pershaw Court? Again, his position is quite straightforward at the outset. He's the sole legal owner. He also asserts he's the sole beneficial owner. He was at the start. And as far as he's concerned, nothing ever changed. He therefore remains the sole legal and beneficial owner. He ran the business until quite recently when Sam took over, but that doesn't matter, he says, for the purposes of his beneficial interest in this property. He wants 100%. And again, he wants to robustly defend any claim that Nina wants to bring in respect of Pershaw Court. So then we get on to the consideration of the counterclaim for Lime Grove. Again, there's no dispute about the ownership legally at the time of the acquisition by Nina. She purchased it entirely in her own name. And it appears also that she was the sole beneficial owner at the time. But shortly afterwards, a declaration of trust was executed, which we say declared her to hold Lime Grove on trust for herself and Ahmed in equal shares. So Ahmed says, I want 50% of that property. That's mine as much as anything else. So when we go to look at the detail of our defence to Teddington, David's already recognised that his big problem is the TR1. Goodman and Gallant, he's already taken you to that. That is conclusive in the absence of a vitiating factor. And we've seen David's particular claim, none have been pleaded. So he's not seeking to rectify or set aside the original TR1 declaration. So I'm home and dry as far as that part's concerned. I plead that they acquired Teddington as joint tenants. That's unaffected by the fact that Nina paid quite substantially more to the purchase price. They declared themselves to be joint tenants beneficially, and therefore that's what they were. David, recognising that, has to come up with some other reasons as to why he can argue that Nina should have something more than a 50% interest. And he's raised the engagement point. And so how do we deal with this? Well, David's already taken you through the law on that and how it might be used to argue for a greater share. And this comes down to a question of credibility and what actually happened on the ground in terms of whether or not the engagement happened. Well, there's no dispute that they did get engaged. Nina appears to have had a nice ring as a result of it. But they differ when they come to the question of whether or not the engagement was continuing at the date that they separated. Ahmed's case is no, it was Nina's choice that she didn't want to get married. I would have married her long ago had she wanted to, but she didn't. And therefore, despite me having bought her a very shiny ring, we broke off the engagement. And at that stage, she started wearing the engagement ring on her other finger. So it was a long time ago. We weren't engaged when we separated. It was just one of those things. It just didn't come to fruition. In any event, the refurbishment that she's talking about didn't really amount to a genuine improvement to the property. Some posh furnishings are just using the property. That's not an improvement to the property itself. And the garden, again, it was limited and it didn't improve the property, and it certainly didn't bring about any kind of value increase. So Ahmed's case is the family law principles have no application to this situation, and David can't rely upon the statute to try and get beyond the civil principles. And I think Ahmed's got quite a good, strong case on that, but it's certainly arguable. So then we go to the stronger line of David's defence, which I think, again, David has recognised that proprietary estoppel is probably his best shot out of a situation which might appear to be unfair on the face of it. And again, whilst I've sought to emphasise the fact that civil courts apply civil law and civil principles to ownership of property, they are only human ultimately. And if a situation feels intrinsically unfair, then if you show them the way of how to find in your client's favour, they're more likely to do that. So a court's faced with a situation here where a couple have been together a long time. They'd bought this property a long time ago in 2001. They've lived there together and made it as a home, man and wife. So far as common law is concerned, but as we know from Anya's opening remarks, that doesn't get them anywhere. But they lived like that. And they had children, and children grew up at the property. And Nina paid £200,000 at the outset in the early days of their relationship, and he only put in £50,000. So how fair is that? So whilst that in itself doesn't get them any further because of the TR1, the court might still have it in the back of its mind when looking at the arguments that David's putting forward. One of the arguments which David hinted at, the ambulatory constructive trust, I think he recognised again this was going to be a difficulty for him, although again perhaps something certainly to throw into the mix, as he said. And the key case which may assist him on that is Jones and Kernot itself, the Supreme Court decision in 2011. And that was quite an extreme set of facts. The parties originally owned a property 50-50. They shared the home and the costs of the home for 8 years, but then they separated. And this is where it gets slightly interesting, because then Mr. Kernot encashed a life insurance policy to buy his own property. And thereafter, he had no involvement in the family home for 14 years. And the court held that that allowed the interest to go from 50-50 to 90% to 10% in Miss Jones's favour. So it was quite an unusual basis for the court to have before it, that property is remaining in joint ownership for such a long time after separation, but found in that case that that was sufficient, given the encashment of the life insurance policy and the lack of any involvement thereafter, that could mean that Miss Jones was able to increase effectively her interest. And I've had a case where I've relied on that, and successfully, surprisingly in one case, to show that the male partner's interest had completely eradicated, and that she was in fact 100% beneficial owner after many years of paying everything and being responsible for everything. But those are the unusual circumstances at the extreme end. And there's nothing that Anya has told us so far, or Priya's instructions, which leads me to think that David is going to be able to successfully persuade a court that an ambulatory constructive trust has arisen in this case, which is going to enable him to get over the Goodman and Gallant point. And he mentioned the case of Pankana and Chandegra in 2012. And the importance of that case, it's a Court of Appeal decision. The importance of it is that it's after Stack and Dowden, which we know is a very important case in this field, and it's after Jones and Kernot. And what the Court of Appeal did was to reiterate the rule in Goodman and Gallant, because after Stack and Dowden, many practitioners started to feel that there was this movement of the courts towards what's fair, necessarily than what was strictly agreed, because of Baroness Hell's comments that one can look at the whole course of dealing, and one can look at more wider factors than what was traditionally thought to be the case in Lloyds Bank and Rossett. And as David confirmed, that has survived Stack and Dowd, and it still exists, but it has been qualified so that whilst traditionally we practitioners thought that you needed to really be able to show a contribution to the purchase price, either at the outset or by way of contributions to mortgage repayments, not necessarily interest only, but repayments, or alternatively some major renovations that had increased the value of the property that might get you into a Lloyds Bank and Rossett common intention constructive trust-like argument. But Stack and Dowden tells us that in a cohabitation context, we're looking more broadly than just that, and that we can look at other factors. So from client's perspective, if you want to argue for that type of interest, it obviously helps to be able to look more broadly at the picture. From a lawyer's perspective, of course, it makes it harder to predict outcomes and therefore makes it harder to advise clients as to what the likely outcome will be. But be that as it may, we go back then to Pankera and Chandigara. The Court of Appeal reiterated that Goodman and Gallant stands and that it is a very high hurdle to overcome, and really put the ambulatory trust argument quite firmly in its box. But did leave open, as David has pointed out, albeit I think implicitly it does say it, but it doesn't make the specific point that you can have proprietary estoppel, but it cites from the specific paragraph that I've got on the screen from Stack and Dowden that no one doubts that such an express trust is conclusive unless varied by subsequent agreement or is affected by proprietary estoppel. And the subsequent agreement sounds fairly vague and woolly, doesn't it? But that's what seems to have been repeated in the Court of Appeal case in 2012. But most practitioners are taking it to mean that proprietary estoppel can still be an exception, but it isn't an exception which is easy to bring. So the other interesting point to take away from the 2012 Court of Appeal decision is that it also dealt with the court's treatment of sham documents. I mentioned sham documents at the outset, and it emphasised that in order to show that a sham document exists, it must be proved and it must be clear that the parties never intended to create, for example, a trust, and that they intended to give a false impression by way of entering into that particular document. And the classic case on shams, Snook and London and West Riding Investments from 1961 was cited and is still the law on that point. So shams are quite difficult to prove. And of course, I mentioned at the outset again, one of those examples of a document being produced for perhaps a mortgage application. And that might be a document, a tenancy agreement that's produced to show that this is a buy-to-let property, but actually the client and their partner is living in the property and never intends to let it out in order to get a different type of mortgage, for example. And that might be an argument later that there is a sham document there. So where does that take us in terms of our defence? Well, factually, Ahmed denies making any of these representations that have been pleaded in David's particulars of claim. In any event, he says, well, even taken at the highest, it's not clear and it's not unambiguous. And he further says, well, the detrimental reliance that David relies upon is insufficient. Look at the value of this property and look at that compared proportionately to what Nina has spent on it, a small amount in comparison on the garden and her furnishings. That, we will say, is going to fall short of being able to show significant detrimental reliance. But it's probably enough to show detrimental reliance if she can prove the representation and she can prove that she spent the money, because that in itself is one of the clear examples of detrimental reliance. But as David's already explained, proprietary estoppel isn't going to get him the same result necessarily as a constructive trust argument. Because in a constructive trust argument, the advantage he has is that once he proves to the court's satisfaction that Nina has a beneficial interest and is able to prove what that beneficial interest amounts to over 50%, then the court is effectively bound to declare that interest, because that's what Section 14 tells us. It's a declaration of existing interests. Proprietary estoppel, on the other hand, is a much more nebulous concept, and it means that the court can effectively do what is just and fair to meet the equity of the situation. So David could end up with a bit of a Pyrrhic victory, and the court could still declare it's 50-50 based upon the Goodman and Gallant TR1 point, and that he can't get home on the engagement point, but he might get a bit of compensation for the amounts that Nina has spent on the property, and that might be where he ends up. But we will take a robust line in any event on that. And the final point to consider in Teddington is the effect of the severance. And again, this is a point, as I say, it comes up quite often in my cases, that people don't realise either that the beneficial joint tenancy has been severed, and we haven't got time, unfortunately, to go through all of the circumstances today when that might happen. But there are many examples where people don't realise that their interests were severed. A charging order, for example, was made against one of the joint owners' interests only, and that action results in what was then a beneficial joint tenancy being severed. One of the two joint owners is made bankrupt. Again, that results in severance. And in certain circumstances, sometimes severance can be presumed from conduct, but again, that's quite difficult to prove. But in our case, a notice of severance was served. It's been checked and it's valid. So what the effect of that is, again, we go back to Goodman and Gallant, and what that case tells us is that upon severance, it's the very nature of a joint tenancy that each takes an equal share according to the number of joint tenants. So we have two joint tenants here, so we're 50-50. So we're back to Ahmed's position, unless David can prove otherwise on any of his other points. So then we turn to Pershaw Court. And the starting point here is Ahmed is the sole legal owner. And we know from Stack and Dowden, although it wasn't a sole name case, but it dates back to the principle that David cited at the very outset, equity follows the law. It's for Nina to prove otherwise. The starting point is Ahmed is presumed to be the sole legal owner and the sole beneficial owner. So far, so good from Ahmed's perspective. But David has raised in his particulars of claim the fact that 1 week before the purchase of Pershaw Court, Nina transferred the sum of £125,000 to Ahmed's account. And then he transferred £250,000, the other half of the 125 that she paid, to the sellers of that property or their solicitors. So we've got a question mark here, and she's saying that this was intended to be a contribution towards the purchase price, and that she was intended to have an interest in that property. And one might take a step back and see that given that they were purchasing the other property, Teddington, the family home, as joint tenants, that it might be to be expected that they would have the second property and that they would own it jointly as well. So we've got two ways of looking at this. We've got to explain the £125,000 because quite clearly a court is going to want to know why she would pay that to him unless it was with the expectation to acquire some form of interest in Pershaw Court. He says it was a gift. He says it was out of love and affection. She just wanted to help him on his way with his business. And we're going to have to consider why was the property registered in his name. Now, the other way of looking at it is the fact that Teddington was purchased as joint tenants, that you might say, well, one would have expected these parties to behave in the same way in respect of Pershaw Court as well, if it was going to be intended to own both properties jointly. Why treat them differently even though they're being purchased in the same year? But the £125,000 troubles me, and I need an explanation that's going to enable me to plead a defence that's going to get over that. I pause just to refer to the presumption of advancement only for completeness. It doesn't apply in any event in our case because this is a payment from a wife to a husband. If it had been a payment from a husband to a wife, then the presumption of advancement would potentially bite, subject to being rebutted, because we know presumptions are solely presumptions and they can be rebutted on the evidence. It's an archaic principle that, of course, we know arises from the expectation that husbands would provide for their wives, which I think that most of us know that probably deserves to live in the history books. Surprisingly, it hasn't yet been abolished by way of Section 199 of the Equality Act being brought into force, which proposes to abolish that. But for all intents and purposes, for today's modern law, it's not something that's generally relied upon or raised. So we've got a potential argument that it was a gift. We've got to explain it from Ahmed's point of view. But let's assume that the court finds it wasn't a gift. Then, as David's explained, the fact that this was an investment property means that the resulting trust analysis is likely to apply. And he's already mentioned the case of Lascar and Lascar. But we do need to warn Ahmed that actually the court might look at the wider conduct, and they might look at the fact that this was effectively a cohabiting couple who happened to have an investment property on the side, and therefore the court shouldn't apply such a strict arm's length transaction resulting trust approach. We have limited evidence at the moment, but based on the evidence we have so far, I think I have to advise Ahmed that he's likely to find that Nina's going to be able to establish some interest in this property, and that it would certainly be in his interests to settle, at least in respect to that property. And finally, Lime Grove, very briefly, this is the property that we may be able to bring a counterclaim. The opposite presumption applies because Nina's the sole legal owner, so we have to prove otherwise. We have an express declaration of trust, which Ahmed produced following the issue of the claim. Anya's checked, or Anya's opposite number has checked, and it complies with section 53(1)(b) on the face of it, and he wants to rely upon it and counterclaim a 50% interest in Lime Grove. Again, the alarm bells are already ringing when a document that's so important, such as this, is produced after proceedings have been issued in a very acrimonious situation. So we need to anticipate potential fraud arguments. We need to question why it was executed post-separation when Nina has bought another property to live in, having left Ahmed in the family home. And we might want to think about obtaining handwriting expert evidence at an early stage, so that we can try and satisfy ourselves of what's happened here. So just a quick run through some tactical considerations from the defendant's point of view. We might want to think about a strikeout or a summary judgment application, given the express declaration of trust on Teddington. But I think, unfortunately, that David's probably raised enough factual issues in relation to the engagement and the estoppel point, which means that it's unlikely that a court, unless we had a very, very robust judge, would be prepared to deal with this on a summary basis. So we're probably not in a strikeout territory position. But think about Part 18 requests. You might think that some of David's pleadings, whilst of course very well drafted, might benefit some further and better particulars about discussions or conversations. His Pershore Court pleading, we might think, is a little bit woolly and a bit vague in certain respects of understanding, no doubt based upon a lack of instructions, but we can try and flush out the difficulties that he may have had taking instructions in a Part 18 request and see what arises. Now, of course, tactically, we need to be careful. We don't want to give an opportunity to just plug the gaps in his case that might exist. So we need to be strategic about when we use that. We might want to think about doing it before the CCMC, so that if he doesn't reply or it's inadequate, we can seek an order at the CCMC without the need for a further application hearing, and therefore try and keep the costs down. So think about that at an early stage. Also think about two rules which are often overlooked. The first is CPR 32.18, notices to admit facts. This is something that's used rarely in cases in my experience, but when faced with notice to admit facts, one has to really think about whether you can or should admit the facts. You might be able to elicit helpful admissions from your opponent. The consequences of failing to respond are fairly opaque in the rules. There isn't actually a consequence apart from in relation to costs. But of course, the court might draw an adverse inference if you're asked to admit something that you then, it really becomes clear that you had no other option. So think about using them, because it can certainly make your opponent uncomfortable if you serve them with one. And beware of Rule 32.19. This confirms that you are deemed to admit the authenticity of a document disclosed under Part 31, unless you serve notice that you wish the documents be proved at trial. And timing-wise, you have to serve that notice 7 days after the document was served, or the latest date for witness statements. Again, this is often overlooked, and sometimes you can get to trial and all the documents are in the bundle, and somebody wants to argue about the authenticity of one of them, and no notice has been served, and then it can become very difficult to try and argue that point. So think about that, particularly in this case, because we know we've got documents that are going to be flying around that people do not admit the authenticity of. I think that takes me on to David to take us through the reply and defence to counterclaim.
Thanks, Michelle. So replies are a bit like re-examination in that 90% of the time they're completely unnecessary and potentially damaging to yourself. But that being said, there are cases that call for them. This case probably would be one. And if you're doing a defence to counterclaim, you may as well chuck in something by way of reply as well. Bear in mind, of course, no obligation to do a reply whatsoever under the rules. And if a reply is being done, there is no obligation to go through every line in the defence and say either admitted, denied, or put to proof. You're not deemed to admit anything in a reply. In a defence, if you don't deal with it in a reply, the defendant's put to proof automatically. But here we would be doing one, I expect, a few points in relation to certainly Teddington, and then we'll have to deal with Lime Grove. With Teddington, the issues are always going to be pretty clear. There are a number of fairly discrete points which will have been set out already in the particulars of claim, but we might need to just address some of the points in the defence. I would be resisting the temptation, I expect, even if Michelle was taking pleading points or saying that further and better particulars were required. I'd resist the temptation to expand on the particulars of claim in the reply on a factual basis. I mean, you could do, but there would need to be a shared understanding with the other side about whether or not pleading points were going to be taken, that things have been set out in the reply that weren't set out in the particulars. If you don't have that understanding, then the better way to do it is always, unfortunately, going to be to bite the bullet and apply to amend the particulars. It's still early enough days when you're thinking about a reply that you can do that without huge consequences, and you're almost certainly going to have permission to do it, certainly if you're pre-CCMC. Michelle makes a great point, which is one that comes with experience, that judges are human beings. And even if you have a pretty crap case legally, if you can make it very clear that justice and fairness should be on your side, judges will sometimes be a little bit intellectually dishonest and find ways to make you win. So one of the things, if I was doing a reply on this case, that I would be reiterating, I mean, I would have mentioned it in the particulars of claim anyway, due to just going through the factual background. But in the reply, I would almost be using it as a sort of an argument, that an emotional argument, that the contribution here that Nina made to Teddington was so disproportionate to that made by Ahmed, that it's disingenuous for the defendant to suggest that, insofar as it is suggested, that difference in contributions is irrelevant to this case. And then I sort of leave it at that, but just leave that hanging as maybe your first paragraph, so the judge is punched in the face with it straight away. And then in terms of the actual issues, you might say, for example, that on the engagement point, if Ahmed's raising factual points about, the wedding ring moving over to the right hand and things like that, just put your version of events to that. That obviously doesn't require an amendment to the particulars of claim because you're pleading two new facts raised in the defence. I might make a legal point there about the improvements made to Teddington by Nina, not needing, for the purposes of Section 37 of the 1970 Act, to increase the value of the property. They just need to be improvements, and then it's for the court to determine what to do about that. Proprietary estoppel, again, there's not a great deal that you can add in the reply there, unless you're going to be changing what you're saying in the particulars of claim. I might just say that if a point is taken about adequacy of the detriment, I would be saying that's irrelevant. Not necessarily saying this is right, but I would be saying in the reply that's irrelevant for the purposes of establishing a proprietary estoppel, and only goes to how the equity can be satisfied. Lime Grove, then, we obviously have to deal with that. I'm assuming that it's been raised by way of a counterclaim for a declaration. We'll be pleading our version of events. On the instructions, there's a bit of a question mark here. Undoubtedly, I'm going to be instructed to plead fraud in some capacity. I have to be careful about that from a professional point of view, because I need to be satisfied that there's an arguable case on the evidence for fraud. I can't just chuck it in because I'm asked to. There seems to be two possible bases for fraud here, and it depends on some of Nina's instructions. I could be saying that just the document is fabricated completely. Nina doesn't remember signing it. I'd need to be very clear with her. Does that mean she didn't sign it, or does that just mean she could have signed it but can't remember one way or the other? If it's the former of those, then I could be pleading that it's fabricated. If she can't remember one way or the other, or even perhaps she does remember signing it but doesn't think that it was supposed to be a declaration of trust, I could plead it in another way, which would be along the lines of it was put in front of her, she was told to sign it, and she was told that its effects were something different to what they are now being alleged to be. And then either say that that makes it a sham or non est factum, or go as far as fraud. So I'd have to choose between those two. I don't think I can really plead them in alternatives to one another. Something that you might want to do before you start drafting the reply in that sort of situation is to consider getting your expert evidence there and then. Now, you've got a bit of time with the reply. It's not as though it needs to be in 14 days after the defense. It just needs to go in with the DQs. So that could be an opportunity if you can get hold of the original declaration that Ahmed's alleging. That might be the opportunity to get some handwriting expert evidence then, and having a look at that. And if that's going to look as though if the handwriting evidence is going to come out saying that clearly is Nina's signature, then you're probably going to struggle, or you might tactically decide that you don't want to start alleging that the whole thing's fabricated. If, on the other hand, it comes out saying no, that there are serious differences, and it's consistent with your instructions, then yeah, maybe you go down the harder route and say, yeah, the whole thing's fabricated. But that's going to be a judgment call that I think I would very much want to be in the same room with the client, looking her in the eye when we make that decision, because there could be some pretty serious consequences if the wrong call is made for the client. So that's going to go in the reply and defense to counterclaim. Directions questionnaires will be coming out either before or around the time of the reply, I expect. And we're going to need to start considering what directions we're asking for. This is plainly going to be multi-track, so we're going to be heading towards a CCMC in any event. So from this point on, it is probably going to be better if I bring in Michelle and we have a little bit of a joint discussion on this case, because pretty much everything from here on is going to be based on judgment calls and experience. You can't go to the case law and find answers to any of this. And so it might be between the two of us, we can give a few views, both in general terms and also in respect of this case study, on how we might approach the various remaining steps of the litigation. So perhaps if we start with the sorts of directions that we'd be looking at at CCMC. Undoubtedly, the lawyers or indeed counsel are going to be speaking to each other about the kinds of directions that might be relevant for this case that emerge from the issues that we've worked out. So I'm going to be asking Michelle what sort of thing in terms of experts she's going to be pushing for on the basis that at a CCMC, the things in dispute are usually outside of cost budgeting are generally fairly narrow, but experts is always going to be one of them. So that's what we're going to have to think about. If we can agree something, then great, but that's easier said than done. So Michelle, what sort of thoughts did you have about experts on a case like this, bearing in mind those points on the slide?
Well, I think we're obviously going to need experts in two fields, aren't we, David? We're going to need valuation evidence in respect of the properties in terms of their freehold ownership. I think we'll also need within that category potentially rental value evidence, certainly in respect of your claim for an occupation rent in respect of Teddington. So that's something that we would probably want the same valuer to be able to assess both to keep costs down. In terms of the type of valuer, I think I wouldn't really be keen on just having a few estate agents values in this case. We've got 3 properties of quite significant amounts overall. So I think we can justify going to a registered RICS valuer who's able to give us a proper full report, CPI compliant, on the valuations of each of these properties. And I think while sometimes when we're only arguing about the interests and then splitting them out later, I think in this case, given the number of properties involved, we're best to probably have a valuation for all of those properties, at least insofar as their freehold interest is concerned. I think you've raised the question, when will the valuations be? What are your thoughts on that?
It would help to have, and I agree with what Michelle's saying there. I think this sort of case, you're definitely in surveyor territory. And one of the reasons for that is that I think you might want to be asking the surveyors to give you views on valuation at various points in time. So at the point of purchase and now, but as well as that, potentially maybe at the point of severance, you would want as well, if possible, the surveyor to be giving a view on the value of any improvements to the property. And that's obviously not something an estate agent's going to be able to help you with. So I really think it's in both parties' interests for a surveyor, and it might cost a little bit more. It might not add that much to have various different values at different points in time, but equally it doesn't hurt, and it might just feed into some of the arguments.
Yeah, I agree. I also think this is a case where I would certainly be advising we do think about a single joint expert, because we're looking at valuations. Now, you may have the thought process that actually having your own valuers is going to mean that you can argue for a higher value or a lower value, depending upon your perspective. But the reality is the judge is then going to be faced with potentially conflicting valuation evidence and is going to have to choose between the two. It's going to increase the costs, because you may then end up having to have both experts attend court and give evidence. And that whole process is then going to become more truncated because they'll need to meet and provide a joint statement. So unless there are really good reasons in this case as to why we both should be having our own valuation evidence, this is a case which I think I would certainly be advising we try and keep to a single joint expert, but one that we've both chosen, agreed on, and have both agreed the instructions, so that there's no room for doubt about what they're being asked to do.
Yeah, I think that has to be right. It may well be that one or both sides come to court with, as in come to the litigation with valuations already, and might be saying, well, why can't we just rely on that? And the point is that you're going to end up in a dispute between the experts that's just going to add huge amounts of additional cost, and probably from the client's point of view, more importantly, time to the whole of the proceedings. And it's unlikely that a judge is going to be hugely impressed by that sort of thing. It may well be, and I've seen this plenty of times, that even if the parties do both want to be instructing their own valuers and have reports already, a judge just says, look, for the sake of proportionality, we're not doing this. You're having a single joint expert either way, so crack on. And I think that would be right in a case like this. There's not such a dispute on the facts of this that go to questions about value that I can really see why it would justify having your own experts. So I would hope that the parties could, even if it might gall them, I would hope the parties could come together on that point.
Yeah, I agree. And handwriting expert evidence, clearly that's going to be needed if Nina is saying this is not her signature on that declaration of trust. I've already hinted at trying to obtain that early, but that is with the caveat that David's just mentioned, that of course, if we've both gone off to get our own handwriting evidence, it's going to be harder for me anyway, because I'm going to need to ask for Nina's signatures for some samples, for example. Now, Ahmed is in possession, one would think, of the original Declaration of Trust because Nina doesn't have it, and he's the one that's produced it. But we're going to need to consider whether the original is actually available, because again, I'm sure you've had this plenty of times, David, a document is produced, but funnily enough, only a copy is ever available, which makes it much harder for the handwriting expert to undertake a proper analysis. It's not impossible, and some of them will say that they can still do it. But clearly, if you've got the original, that's much, much better evidence for them to analyse. And again, I think I'm leaning towards a single joint expert on the handwriting issue, albeit that this could, of course, conclude the case either way for the one of us. So it might be that, given the allegations of potential fraud, that we might lean towards wanting our own. I don't know, what's your view?
I think where you've got a potential fraud allegation, for the reasons I said as well, I'd already have my own handwriting expert at this stage if I could get one. So I would probably just be wanting to rely on, if that handwriting expert was in my favour, then I'd want to be relying on that handwriting expert. If it wasn't in my favour, I wouldn't be running the point. So I would probably be wanting to use the one I've got. I mean, bear in mind as well, alongside with handwriting, alongside having the original document, you're going to need between, well, at least 5. Usually they want 10 plus signatures, wet signatures, contemporaneous to the document that's being impugned. So that means you're going to need to find a whole bunch of signatures from when Lime Grove was bought. Now, for some people, that's fine. They've got lots of records. They've got plenty of examples of their signatures. I've had cases completely derailed because you embark on this path of getting handwriting experts, and then it turns out that actually the person who's wanting to benefit from the handwriting expert doesn't have any signatures from the time, or has like one or something. And you end up having delays after delays after delays where they're trying to get more evidence in, and then coming back for more signatures in, and coming back for further directions when the point arrives where the expert says, I'm not going to be able to do a report. And then what do you do? So I think it's bottom all of that out before you start embarking on that sort of journey, and let that influence your tactics.
Yeah, I think you're right. I think because it's interesting now, we're moving into this electronic world, and Lime Grove was only purchased in 2019, and I'm struggling to think how many documents I was signing around that time with a wet signature. So as we move forward, I think it's going to be harder and harder for people to have signatures to compare. The alternative is it's a very long time ago, and as David said, people don't have the signatures for there either, but it's certainly something to start doing your research and digging in and digging down into at an early stage in the case.
The next point I've raised, you identify these experts in advance, or just wing it at the direction stage. Obviously, it's preferable to identify them in advance, but you can just get away with it by just identifying their area of expertise, especially if they're single joint. Moving on from experts, I've thrown in restrictions on witnesses. There shouldn't be restrictions on witnesses ever, really. But I know Central London County Court's doing this increasingly, or at least it was. I don't know if they've been told to stop, where there are some circuit judges who at CCMC are saying that you can only have like 2 live witnesses at trial, or even just 1 live witness at trial, in an attempt to streamline everything. I mean, it leads to it creates just a farcical situation where it's impossible to know how much weight can be put on the hearsay evidence of those witnesses who weren't allowed to come to trial. But it does sometimes arise. You might know of a few judges and a few courts that do it. You might want to consider if that could be to your advantage. Birmingham doesn't do it, as far as I know. I don't know of any local courts particularly. I don't know if Michelle has come across this.
I have, and Birmingham is doing it now, actually.
Oh, good.
So sometimes by its own motion, I've had judges at CCMCs impose a restriction on witnesses. I think Emma Kelly, certainly as a district judge, was quite keen on that. Of course, she's now a circuit judge, so she's unlikely to be dealing with that many CCMCs, although they still do put them before circuit judges occasionally. And certainly I've asked for it when I know the other side is asking to call a lot of witnesses, and tactically I want to restrict it. I've invited the court, the CCMC, to restrict it to a number. The judge will normally obviously go somewhere between the number you ask for and the number they say they're going to call. But it can be quite helpful, particularly if you're arguing that from a proportionality perspective, the case is not going to be to finish in the time that you've both proposed. And so judges will sometimes use their case management powers to do that, to restrict it to the time that they think should be allocated.
The last 2 points are the time estimate. You're going to be able to work that out, and in person or remote. All I would say, and I'm sure we're all aware of this now, is that if it's going to be remote, add about 50%, if not double the time estimate that you think it's going to be. And a good rule of thumb anyway with time estimates is to take however long you think it's going to be on a worst case scenario and just add a day, because you never estimate enough time. Counsel don't, certainly. And it's just horrendous. We've all been through the situation before where you don't finish the evidence on the last day of the trial, or even you do, and then you have to start thinking about written submissions and coming back for judgment and all that sort of thing. If you can get it done in an actual allotted trial time estimate, it just makes everyone's life easier, and the clients will obviously be a lot happier. ADR. The question of an FDR, certainly in ToLATA cases, is always one to consider at CCMC. Birmingham likes them. I don't know so much if other courts do or not. Everyone has different experiences of FDRs. I'm not a fan. I don't think they necessarily add that much. I don't think the indications that judges give are that helpful. That being said, the value of an FDR is that everyone and their lawyers and the parties are at court, and hopefully with a settlement hat on. So you can treat them as a very useful, without prejudice meeting, if nothing else, to maybe make some headway. I've certainly settled cases at FDRs, not based on the judge's indication, but just based on the fact we were all there, and just decided we worked out we weren't actually that far apart, so we just stuck with it until we got to a settlement. There can be value in that. I don't know if Michelle has different experiences.
Yeah, I've had varying experiences with FDRs. Some have been successful in the sense that the indication given by the judge has been helpful and has allowed the parties to move in the right direction of settlement. I've had some fairly unhelpful indications. The best example was the judge just said this is all very complicated and threw his hands up in the air and said it's 50-50. Which didn't really help anyone. Incidentally, in that case, we did settle. So I think David's point is a valid one. Sometimes just having everybody there, you can almost use it as a bit of a cheap mediation, in the sense that you're not paying the court to undertake that role. But they can also add an additional layer of costs. That means that you just end up with incurring more costs that you don't actually get anywhere. And my view of mediation versus FDR is generally mediations are much more likely to result in a settlement, almost because everyone's in their rooms with the mediator truckling between them, rather than a 2-hour hearing with a judge giving an indication. I do think that the pressure of mediation is more likely to lead to a settlement than an FDR, in my experience.
Yeah. I'm looking at the time, and Michelle and I have done what we do, which is witter on far too long. I think let's just touch on offers and consequences of offers. And then in relation to the rest of the litigation, you've got the slides, or they'll be coming out, and they go into some detail about things to consider. But I'm just conscious that we need to give Eloise a fair crack of the whip on remedies. So in terms of offers, Part 36 is in ToLATA. That's always a tricky one, because of course you're not just offering an amount of money, but I suppose there's no reason why you couldn't make a Part 36. I think I would probably go down the Calderbank route myself, but I mean, what experience do you have with that, Michelle?
Yeah, I have made them. You're right. You have to be very careful that you don't fall foul of it not being a valid Part 36 offer because of what you're seeking to do. But it is possible, and obviously the advantage, certainly from a claimant's perspective, is putting more pressure on Ahmed's shoulders if Nina makes a well-pitched Part 36 offer, which is compliant, then he may have to really consider his position. And of course, remember that you can make offers in respect of parts of the claim as well, which I think is sometimes overlooked in people's views when they're settling. So as I mentioned, I think Ahmed's got a weaker case in respect of certain parts. And so it might be that Nina wants to put pressure by trying to cut out one of the properties, for example, or vice versa. So think about being a bit more creative with the settlement. It doesn't have to be all or nothing.
Yeah. Cost consequences. We're not going to go into the cost consequences of Part 36. The cost consequences of Calder Bank offers are always a bit more woolly. They can be evidence, if they're unreasonably rejected, of unreasonable conduct for the purposes of 44.2, but they're not sort of a panacea. Mediations are always an interesting one. If there's been or any sort of ADR, sort of WP meetings, mediations, that sort of thing, if there's been a rejection by one side of a properly formulated offer of mediation or a WP meeting, the case law very much is on the basis, the tenor of it now is that rejection without more will be unreasonable conduct, but that will be with regard to, amongst other things, whether that mediation had any real prospect of success. And that is something that you get a range of judicial interpretations of. And some judges take the view that, well, if it wouldn't have gotten anywhere, if it was just unlikely to lead to a reasonable resolution, then it's not unreasonable to have rejected it. But on the other hand, some judges take account of the fact that, well, if you allow that as a get out, it just means that all the party has to show is that they're so utterly unreasonable that they would have never settled at mediation, that the mediation had no real prospect of success and therefore it can be rejected. So there's a bit of a balancing act. I would generally say that rejection of a mediation is a bad idea. You are opening yourself up to some pretty difficult cost consequences to get over, cost arguments to get over, if you reject the mediation, even if you then win at trial. If you only partially win or indeed lose, having rejected a mediation, then things are going to go very, very badly from a costs point of view. I have lay clients who desperately don't want to mediate, and it is difficult, but I do try my best to bring them round to it, because it just is absolutely in their best interests.
Agreed. I couldn't add anything else to that. Thank you, David. Well, I think we're both going to hand over to Eloise now for having a look at remedies and solutions. And as David said, you've got the notes on the last few sections on witness statements and trial prep, as you can see there. So please go away and read them at your leisure.
Thank you for that. As David and Michelle said, I'm going to be dealing with the remedies aspect of the ToLATA claim. And I'm particularly going to be focusing on some of the remedies that Ahmed and Nina might want to be seeking. Now, I want to keep it as practical as possible, but before we deal with some of the specific remedies, I wanted to just touch back on the court's powers and discretion with respect to ToLATA claims. I know Michelle's already touched on this slightly, but we'll just look at it again with a focus on remedies. As Michelle raised earlier, the relevant part of the Act is, of course, Section 14. As Michelle said, the court does have wide powers, and it's important to note that they go beyond what a trustee might have when they're exercising their powers under a trust. An important point to also note is that those powers are declaratory, and we'll touch back on that again later. The next relevant section is Section 15, which sets out the matters that are relevant to determining the court's discretion. Those are the intentions of the people that created the trust, the purpose for which the property subject to the trust is held, the welfare of any minor who is occupying the property, and the interest of any secured creditors. What's important to note about that is that those possibilities are not exhaustive, and they're also not weighted. So, for instance, one might think that the welfare of a minor or a secured creditor might come first in the court's discretion. That's certainly not the case as a matter of law. What the practical considerations of the judge are may well be slightly different. And importantly, again, it's important to consider that that discretion is wider than that of a trustee exercising powers under a trust. So, as we'll touch on later with respect to an order for sale, the court can make orders that, for instance, may not achieve the best price for a property. Moving then now to some of the specific remedies that might be relevant in this case, and I've set those out on that slide. But helpfully, those are also line up with some of the most common remedies sought in ToLATA claims. The first is that of a declaration. Now, we can deal with this remedy in fairly short order. Essentially, it will be a declaration that reflects the court's decision with respect to the beneficial interests in the land. What's important to note, though, about the declaration, as Michelle touched on earlier, is this is not a point at which the court can begin to make a decision about what they might think is fair. It's simply a recognition of the court's exploration of the beneficial interests in the land. The next common remedy, and certainly a remedy sought in this case, is that of an order for sale. Now, previously, prior to ToLATA, the court would have been looking for exceptional circumstances to make an order for sale. Whilst the court was moving away from that approach prior to ToLATA, it's certainly clear following ToLATA that that's no longer necessary. Instead, the court are going to be focusing on those factors that are set out within section 15. That means that there's much greater scope now for the court to make an order for sale. What the court will be considering, and one of their primary considerations will be, is the purpose of the trust. Now, if the purpose of that trust has come to an end, the court are going to be likely to be willing to make an order for sale. So taking the example of Ahmed and Nina, and certainly Teddington, in which the property was the family home, if the relationship has broken down and the parties are separated, the purpose of that trust being the family home has come to an end. The situation may well be different in the context of a business scenario. If the business is still ongoing from a certain premises, the court might be more reluctant to make an order for sale in those circumstances. Whilst I appreciate there's no minors in this case, the children are adult children, I just wanted to raise the issue of minors occupying the property, because that's likely to be relevant to a number of other claims. If there are children present at the property, the court will need to be aware of the welfare of those children. And if that's their home, again, the court might be reluctant to make an order for sale in those circumstances. Now, I don't want to give too much detail about the practicalities of an order for sale. I'm sure everybody joining this call will be very familiar with what kind of information is needed in the court order, such as the need for estate agents to be agreed and an agreed party to conduct the sale. But what I did want to raise is some potential more creative possibilities in making an order for sale. The court don't have the power to make a transfer of the property, but what they could do is make an order that one of the parties has first refusal to purchase that property, whether that be at a market rate or possibly less than a market rate. And that's where we tie back into the fact that the court has a greater power than a trustee acting under the trust. The court can make that decision even if it wouldn't necessarily achieve the best price for the property. Another potential more creative solution that the court has previously ordered in the case law is that of placing the property for auction. This might be a useful solution to bear in mind if you've got two parties that are looking to take on the property moving forward. That would allow the parties to then competitively bid for that property. It might be a helpful solution in some cases, but it certainly might be worth bearing in mind that if you've got very acrimonious parties, it might certainly drive up the costs or the price that's paid for that property. I can certainly envisage a situation where somewhat unrealistic offers might be made just to annoy the other party. But I just raised those two as potential options that may well provide a helpful solution depending on the facts of any specific cases that you might be dealing with. The next remedy that I'm going to touch on is that of an equitable account. Now, you'll see that I've put on the slides here, you get back what you put in. And I think that's a really helpful way of theoretically considering what an equitable account is. Essentially, in taking an equitable account, the court are going to adjust the net proceeds of the sale to take account for various contributions and benefits that arise. What's important to bear in mind here is that an equitable account, by virtue of being an equitable remedy, is going to be extremely fact-specific. And it is difficult to give a set of general principles that can be applied in all cases. That notwithstanding, I'm going to try and draw out some of the common and more practical points that are going to be relevant for equitable account. But certainly bear in mind that this is going to be very fact-specific and tailored to individual circumstances. Now, the first point that I've got on the slide here is a common sense one. The beneficial interest needs to be established prior to conducting the equitable account. But it is an important one because the contributions made are relative to the overall interest in the property. So whilst that is a common sense point, it's helpful to have a reminder of the importance of that. The next more practical question I want to look at is, over what period should this equitable account cover? At what point should the equitable account begin? Now, as a general rule that the court might apply is that it's from the point at which the purpose of the trust comes to an end. So if we take the example of a family home and a relationship, during the course of the relationship, there are established ways in which the arrangements for discharging the outgoings are set up, and they go to the purpose of the trust. But when that purpose of the trust ends and the parties separate, there's no longer that usual situation for the outgoings. And at that point, the court is likely to find that the parties should discharge those outgoings proportionate to their share in the property. So if we consider that example of a relationship, the parties are likely to find that it's from separation. But if we look at other contexts, such as the investment property, the result might be slightly different when looking at that. But that isn't a general rule. There are other circumstances in which the court might think it is an appropriate remedy to have an equitable account. And an important thing to consider is, has there been an agreement between the trustees as to how outgoings should be shared, and has that agreement been breached? If there is an agreement and that's been breached by one of the parties, the court might think it's appropriate to have an equitable account that takes account of that. Now, the next general principle I want to have a look at is, when should the court actually undertake the process of an equitable account? Now, a lot of the reading that you might do around this and equitable accounting might suggest that it's preferable to have that following the sale of a property. That means that the court can then deal with real figures. If we're looking at valuations, they are inherently more theoretical, but that certainly does draw the importance to the theme that was picked up by both Anya and Michelle and David about having a really good valuation of the property. And if that provides us with a reliable figure, then that certainly provides us with a better figure to work from and makes that a little bit less theoretical. And of course, that won't be possible if there isn't going to be an order for sale. So it is really important to have those firm valuation figures ready for the final hearing. That brings us on to the next question, which is a further hearing going to be necessary? Equitable accounting is a relatively administrative exercise, and it should be possible for that to be dealt with at the final hearing. It's certainly going to be in the interests of the parties to do that. First, it's going to reduce the cost of having to come back for another hearing and incur further fees with respect to that. But second, it prevents the proceedings going on for longer and provides us with some finality. And that's certainly going to be important if we are looking at a relationship between the parties. It's going to be particularly important for them to have finality to move forward with things. Again, that might be important in a business context if these proceedings are holding up any developments with that business. So it's important to bear that in mind. If it is going to be possible to proceed at the final hearing, there are important practical implications for that need to be considered in advance. The parties need to ensure that all of that information is ready for the final hearing. So that would include having a suitable valuation of the property and any necessary evidence of, for instance, mortgage contributions or outgoings. If for whatever reason that information isn't available at the final hearing, then it will be necessary to list the matter for another hearing at which the court considered that equitable account. If that is going to be the case, it certainly should be possible to agree the calculation by which the court are going to consider the equitable account. And at the very least, the parties should be endeavouring to agree that as part of the hearing, and the possible calculation should be recorded within the order. I now want to move to having a look at it practically in terms of the types of contributions and outgoings the court might take account of as part of that exercise. And I'm going to go through those items that are listed there on the slides in turn. So in relation to renovations and improvements, it's really important to have a clear distinction here between renovations and improvements that took place during the course of dealings between the parties and those that took place within the period where the equitable account is going to be taken. Now, renovations and improvements during the course of dealings between the parties are likely to already have been reflected in the beneficial shares that the parties have, if that is appropriate to do so. They then can't be brought up again in relation to the equitable account. When we're looking at renovations and improvements in relation to equitable accounting, we're looking at things that have happened after and things that have happened during the period over which we're taking the equitable account. So for instance, in this case, where Nina has raised the question about her refurbishment of the property, that wouldn't be something that we would then take account of as part of our equitable accounting exercise. Whilst it's not relevant to this case, I do just want to touch on it briefly, should it become relevant in any of the cases that you might be dealing with. It's very important to find out from the client whether those renovations and improvements were completed by consent. That's crucial because if they were carried out unilaterally, there won't be any recognition for that in the equitable account. But if there is evidence of that being an express or implied agreement for that, then certainly credit can be given for that. So you'll want to be considering evidence of any agreement, for instance, if there was any discussion about the work, or for instance, being aware of the costs of those works. And in terms of how that would actually be quantified in the equitable account, the court are likely to be looking at either the increase in the value of the property or the actual expenditure. And importantly, it will be whichever one is less. The court are going to be very reluctant to start having an equitable accounting exercise for a renovation or improvement that's actually had very little effect on the value of the property. So for instance, if Nina purchased all of those soft furnishings after the breakdown of the relationship, the court aren't really going to want to start having an equitable account in relation to that. The next and perhaps more major consideration in an equitable account is that of occupation rent. So an occupation rent will become relevant where one party has remained at the property and had exclusive use of it. An occupation rent will essentially be a charge for enjoying the entirety of that property. And the relevant sections I've set out there are section 12 to section 15. We've already gone through section 14 and 15, but section 12 of ToLATA provides us with the right to occupy, and section 13 provides us with a bit more information about where that right might be excluded and the reasonableness consideration. Now, I've put the question at the top here about whether ouster is going to be necessary. Certainly, following ToLATA being enforced, an ouster or a forcible exclusion from the property is not necessary to establish. There is going to be a much wider consideration in relation to that, and the court will be looking at the considerations set out within section 12 to section 15. So it's not going to be necessary to establish that Nina was forced out of the property. Whilst it's not necessary to show ouster, it doesn't mean that occupation rent is going to be awarded in any case where one person has remained at the property and the other has left. And it's not going to be an automatic entitlement. So some case law examples of where an occupation rent wasn't considered to be awarded are circumstances where the other party allowed the occupying party to remain and didn't seek an order for sale. Another example where an occupation rent might not be awarded is if a party voluntarily left, but the person was always welcome to return to the property and enjoy their right of occupation without any unreasonable restrictions on it. In that sense, I can't see many, certainly family relationships where that's likely to occur, or indeed any business relationship where that's likely to be possible, but it's certainly something to keep in mind. And again, it's not relevant to the facts of our case today with Sam and Neil being older, but if there are children at the property, the court might well be reluctant to award an occupation rent where that has been their home. So those are just some factors to bear in mind in relation to considering if an occupation rent might be suitable. In relation to the quantification of that rent, there isn't an established principle with respect to this, but generally and traditionally, the court have taken a mean profit approach with relation to that and haven't made a strict rental calculation or looked at an open market rent. Generally, they'll look at the notional rental value or the cost of alternative accommodation. And then the very final point that I'm going to be touching on today is with respect of mortgage payments. Now, in this case, the mortgage payments have continued following the separation of the parties, and there is some factual dispute about how much each of the parties has contributed following that separation. But certainly, Nina is alleging that she's had a greater interest, contributed a greater part of the mortgage since separation. So that certainly would be something that is relevant to the equitable accounting exercise. It's very important to draw a distinction here between the capital payments, those payments that actually increase the net equity of redemption on sale, and those payments that go to the interest. With respect to the capital payments, as I've set out there on the slide, credit will be given for those usually within an equitable account. With respect to the interest payments, the position is slightly different, but there certainly is authority that the court will be willing to offset the interest payments made by the occupying party against any occupation rent that they are ordered to contribute. That sums up the position in relation to the remedies that we'll be going through today. What we're now going to do is just hand back to Priya very briefly, who's going to give us the judgment in relation to our claim today, that being the much awaited judgment.
Thank you, Eloise. I have been told I can't give a full judgment today. We don't have the time, and I am sorry we're running over slightly. I'm going to give you the outcome because I don't want any of you to be wondering what happened to Nina and Ahmed forever. But I will follow it up with a fuller judgment by email if you'd like one. So in respect of Teddington, the judge finds that the equity follows the law and nothing has persuaded him otherwise. Teddington is owned 50-50 by Nina and Ahmed. Nina retains 100% of Lime Grove, the declaration of trust having been invalid. And in relation to Pershore Court, Nina is awarded her contribution to the purchase price, in addition to any prorated increase in value. And there is no order as to costs. So I would like to get to a question that we've had, and I think Michelle and David are ready to answer. I'll just read out this question first so that everybody has it. From an anonymous attendee, we have a question. I have a case at the moment where my client is a tenant in common and holds a 50% beneficial interest in a property. The other party's solicitor has argued there is no express declaration of trust as the TR1 was not signed. It is therefore invalid. Box 10 of the TR1 indicates tenants in common and equal shares, and there is a restriction on the property title to this effect. The other party's solicitors also originally acted for both clients in the purchase. Question is, does an unsigned TR1 override the express declaration? I am going to pass over to Michelle and David, who I hope has an answer.
Well, as always is the case in this area of law, it's never quite that straightforward, is it, Priya? Well, I think we're assuming for the purposes of answering the question that the TR1 was signed in the sense that it's obviously been registered at Land Registry, and we presume that what this means is that it was signed by the seller, but not by the purchasers. So the question that arises is whether the fact that box 10 was ticked to confirm that the purchasers would be holding the property as joint tenants in common is valid when they haven't signed the document. And I think the starting point to the question is to go back to basics, which is section 53(1)(b) of the Law of Property Act, and that confirms a declaration of trust respecting any land or any interest therein must be manifested and proved by some writing signed by some person who is able to declare such trust or by his will. So the declaration has to be in writing, it has to be signed by a person who is able to declare the trust, and the question therefore flows is, does the TR1 affect a valid trust? My view is it doesn't. On the face of it, we have to look at the form itself. And the difficulty with the form is that whilst box 10 was included within the TR1 when it was amended to try and deal with the problem that people didn't make declarations of trust, but there's no express requirement that the purchasers always sign the TR1. So what sometimes happens is only the sellers do. But the form itself confirms if there is more than one transferee, which there seems to be in this case, and panel 10 has been completed, each transferee must also execute his transfer so as to comply with the requirements of section 53(1)(b) of the Law of Property Act. So certainly the form itself envisages that the purchasers should be signing it as well, because of course it's them who have it within their power to declare the trust. And that has been found to be the case in a High Court decision called Insult and Cowlam in 2017. And a similar situation arose where the TR1 confirmed that the beneficial interests were to be held as joint tenants in that case, but it had only been signed by the transferors and not the purchasers. And it was found, therefore, that couldn't amount to an express declaration of trust, albeit that the court did go on to find or consider whether there was a constructive trust and whether or not it was therefore evidence of their intentions. But as I said at the outset, it's always the case, it's not quite that straightforward, and David will help us on where that difficulty might lie.
Well, yeah, there's conflicting authority. And for what it's worth, I think what Michelle's just said, and I know Michelle shares this view, is that that is all correct, and that the case that she cited should be the one that's preferred. But there is another case from the same year that's also High Court called Taylor and Taylor, which is 2017 EWHC 1080, which concludes the opposite result. And Taylor and Taylor, the judge says that 53(1)(b) is satisfied by the vendor signing the TR1 on the basis essentially that the vendor of the property is the settler of the trust, which is then set out in box 10. Now, I don't quite see how that gets round to the point Michelle's making, that it's pretty clear that for that to be a binding declaration of trust, the purchasers need to sign it as well. But that seemed to be what was being said in Taylor and Taylor, that didn't matter, that the trust was set up, and that it would only be if you're changing subsequently the beneficial interests that you would need to have the purchasers involved. So who knows is the answer there. I think if it were to come back again, I think Michelle's interpretation in the Insult case would be the one that would be preferred, but it just goes to show this is a tricky area. None of the statutes are that clear, and there isn't that much case law on precise circumstances that can be relied on. It doesn't help by the fact that the TR1 has changed in the last however many years, and a lot of the case law predates that change. So there you go. It's not a risk-free matter to pursue.
Well, I think that deals with all the questions that we've had. So thank you, David. Thank you, Anya, Priya, and Eloise for that very helpful wrapping up of Remedies. We hope that you found the property conference useful. We hope that the next property conference will be in person, and that these webinars, they will continue, but on a smaller basis. So hopefully we'll get to see as many of you as possible next time round in person.